Yes, sir.
Yeah, as the summit chair, I welcome all of you and I request Mr. Rohit Kochar, the regional president, Indo-American Chamber of Commerce, under whose auspices this second Indo-US legal services has been organized so successfully. So over to you, Mr. Rohit Kochar, to give your welcome address.
Thank you very much, Dr. Vaseem. Good evening, friends. In my capacity as a regional president of the ISCC, it gives me great pleasure to welcome you all to this second Indo-US Legal Services Summit. A special warm welcome to our chief guest, Mr. Tushar Mehta, the Solicitor General of India. Mr. Mehta, of course, needs no introduction. He is one of the most eminent legal personalities of the country and also a household name. Thank you very much, sir, for joining us this evening and taking your time from your extremely demanding schedule. I think everyone knows much about you and you're widely read about in the Indian newspapers on a regular basis. I did want to mention on a personal note that I'm delighted. I have one thing in common with you, sir, which is we both commenced our journey of the practice of law 35 years ago in the year 1987. Friends, India and the United States are fascinating countries in so many ways. One is the world's largest democracy. The other, the world's richest and most vibrant democracy. One is the financial services capital of the globe, and the other, the global offshoring and outsourcing hub. The business relationship between our two countries is truly symbiotic, and our economies are intertwined in so many ways. Just illustratively, last year, the United States surpassed China to become India's largest trading partner. And the figures are really staggering. $119 billion was the bilateral trade between India and the US in 2021, up from $80 billion during the preceding year, witnessing a staggering 40% increase. It's about 38, 39 something. I've rounded the figure off to 40. As we all know, friends, the US also continues to be the single largest investor in India, albeit some of these investments historically have been routed through Mauritius and now increasingly through Singapore. Many people may not be aware, but last year in 2021, India became the largest purchaser of oil from the United States. As COVID recedes, new forms of global turbulence have emerged, which affect both India and the US in so many significant ways, and really underscoring how closely connected our two countries are, both in terms of our fate and our fortunes. Numerous challenges deeply afflict us, and just to name a few, the ramifications of the Russia-Ukraine war, a massive inflation which has engulfed both India and the US, increasing oil and commodity prices, which we talk about every day now, supply chain constraints, food scarcity, and also climate change, which is one of the most important topics for the summit today. We're also two great nations with common agendas. These include a shared vision for the future of a free world Our enduring belief in the rule of law also binds us so closely together. Given the commonality of challenges, goals, and values, I believe India and the United States are entering an era of the closest ties that we have ever seen during the last many decades. Friends, it is in this backdrop that the Legal Services Summit of today assumes much significance. No business and investment can succeed, be it domestic or cross-border, without proper legal counsel, both within and outside the courtroom. It's been a great pleasure addressing all of you, and I'm sure you will enjoy what promises to be a very engaging and interesting Legal Services Summit. Without further ado, may I hand over the proceedings to Dr. Lalit Bhasin, our National Executive Vice President.
Thank you, Rohit. Besides our worthy chief guest, Mr. Tushar Mehta, the Solicitor General of India, we also have two distinguished guests of honor, that is Justice Judge Sanjay Taylor, Presiding Judge, County Division, Circuit Court of Cook County, Illinois. Now he's earlier, prior to when he became, a judge, he counseled Fortune 500 companies and sat in 5 different divisions of the circuit court and has heard many high profile and high exposure cases. He's currently presiding judge in charge of a division of the circuit court and is the first Asian American presiding judge in Illinois. On June 28, that is not even 1 month ago, 2022, Cook County voters overwhelmingly elected him to circuit judge, giving him 82% of the vote. And he's a friend of the Indian legal profession, having been a part of 4 visits, mutual visits between the legal ABA representatives and the representatives of the Society of Indian Law Firms of India. We also have the distinguished presence of Ms. Audrey Slover, who is the acting Economic Growth Unit Chief of the United States Embassy. She is the economic pillar of the Indo-Pacific Strategy as a part of New Delhi's Economic Growth Unit and currently the acting Economic Growth Unit Chief. I welcome our guests of honor, both Judge Sanjay Taylor and Audrey Slover. Now, we are celebrating 75 years of India's independence, but we are also simultaneously celebrating 75 years of India-US relations. And our relationships have grown not only on bilateral basis, but as the recent development would show that India and United States are not only part of Quad, where Australia is also, a partner, and Japan is also a partner, but also what is known 2 U's and 2 I's. 2 U's mean the United States and the United Arab Republic, and 2 I's, that is India and Israel. That is another group formation headed by the United States and of which India is also a part. So it is growing not just on bilateral basis. We are trying to expand our relationships. Now we have chosen 4 subjects. I think on paper they look quite different and distinct, but there is a running link through the 4 topics. As the first topic shows, laws may still be different, but still there is commonality and mutuality. That is the first part. Now that leads to the second link, rule of law, for the reason that both the countries, as Mr. Rohit Kochhar rightly pointed out, we are the largest democracies in the world, two largest democracies in the world, and having the two largest lawyers in numbers in the world, you see, almost the same, over 1.1 million in each country. For the reason that both countries, as largest democracies in the world, are committed to rule of law. They are committed to rule of law and all the institutions that go under the name of rule of law. And this leads to, for this commitment to rule of law, the legal profession of both countries have played important role. That is, a large number of US presidents have been lawyers. In India, we have had presidents, prime ministers, they were all lawyers, and our father of nation and our first president of India, our first prime minister, they were all lawyers. And even after independence, lawyers have continued to play a very important role as cabinet ministers, as law officers, as Mr. Tushar Mehta is, as the Solicitor General. Then additionally, the bar associations, that is like American Bar Association, Society of Indian Law Firms, Bar Association of India, have actually promoted Indo-US cooperation. I remember the time when the first ILEX delegation sponsored by ABA came, of which Mr. Jaipur Jain and Judge Sanjay Taylor were an integral part, and that was led by Eric Wolf of DLA Piper and Mr. Aaron Shildos. They won our hearts and they invited us, and we went about 3 times as in exchange delegation along with our very active member, Mr. Shikhil Suri. He played a very important commerce, like the Indo-American Chamber, important role. These are the 3 topics. Now someone will say, what is the 4th topic to do with the Legal Services Summit? I'm only reminded of what the United Nations chief said very recently, said that we have a choice, collective action or collective suicide. Humanity faces collective suicide over climate crisis. That is these are the expressions you see of the United Nations chief. Therefore, here India and US, if our rule of law is to survive, or even if we have to survive climate change, we as members not only of Indo-American Chamber of Commerce, but as legal professionals, I think a duty is cast on us to inform our governments, to inform our clients, the business houses, how to ensure a sustainable development which should not lead to suicide. So this is the link you see of the subject, and we have very, very eminent speakers today. And the mode of presentation is that one speaker from the United States and one speaker from the Indian side, they will present their views. So it is not a panel discussion. It is the views of the representatives of the 2 countries, the representatives of the 2 legal professionals. So with this now, I request our guest of honor, Ms. Audrey Slover, Acting Economic Growth Unit Chief, U.S. Embassy, to deliver her address. I think I'll first request Mr. Tushar Mehta because he's got some commitments and he told me that he has to go. So our chief guest, Mr. Tushar Mehta, Solicitor General of India, to deliver his presidential address. Over to you, Mr. Mehta.
Thank you, Dr. Bhasin. Thank you so much. Good evening to all of you. Ms. Audrey Slover, Judge Sanjay Taylor, my dear friend Rohit Kochar, Shikhil, Ms. Lisa Sevit, Mr. Sanjay Notani, and my friends Amit Kapoor and Ronak Desai. It's my proud privilege to address during this IACC second Indo-US Legal Services Summit organized by Indo-American Chamber of Commerce. This is with the active support of the initiative supported by the Society of Indian Law Firms, the Confederation of Indian Industries, National Committee on Legal Services, and the Chartered Accountant Institute of Arbitrators in India. Federation of Indian Corporate Lawyers have also joined, and more importantly, by the South Asia and India committees of the ABA International Law Section. Very interestingly, the Chamber has taken a very appropriate selection of topics for today's discussion during this summit. The topics are, as it is already pointed out by Dr. Bhasin, prima facie appears to be different and distinct, but inevitably linked with each other. Mutuality and commonality of laws of US and India, commitment to rule of law, role of organizations like ABA, SILF, and Chamber of Commerce in promoting the economic cooperations, and perils of climate change and responsibility of the legal profession. All of them will have to be seen together rather than looking at them as individual topics and topics of discussion by subject experts only. India and United Nations economic and strategic cooperation is a dynamic process, always setting up new challenges and new visions. As a partner in progress, IACC has been providing a very constructive platform for crafting a national debate on different aspects of legal conundrums that impact the economic growth strategies and to make India a $5 trillion economy. Legal reforms are critically important to achieve that target and to realize our Honorable Prime Minister's vision of Atmanirbhar Bharat. You might agree, we had a stimulating inaugural session which has thrown open many ideas and innovative approaches. There is nothing called a static in business dialogues. New challenges and issues would crop up from time to time. Let me assure you that IACC would continue to flag such issues and provide a platform for discussing them in an informed manner, like what has been done today. Friends, I am indeed very grateful to be a part of this program today. I wish this program very great success and let something more fruitful come out of this program. I thank Dr. Bhasin and other coordinators who have given me this opportunity, and I rest here. Thank you so much. Namaste.
Thank you, Honorable Solicitor General, Mr. Mehta, for a very illuminating inaugural address where you have highlighted the need for better cooperation, coordination between the two countries, that is the US and India, and also among the legal professionals who have great responsibility because without legal support, nothing can be achieved. You may need to have protocols, you may need to have conventions, bilateral agreements and all that. But how do you draft them? You need the legal support for that. That is where the role of the legal profession also comes in. Now with this, we move on to our guest of honor, Ms. Audrey Slover, Acting Economic Growth Unit Chief, United States Embassy. Well, great welcome to you, Ms. Slover. So over to you.
Thank you so much, Dr. Lalit Vasan. I really appreciate that wonderful introduction. And it is my honor to be speaking after Mr. Tushar Mehta and alongside all these other esteemed speakers. Ladies and gentlemen, good evening. Thank you for inviting me. I'm delighted to be here and to have the opportunity to meet with you all at the invitation of the Indo-American Chamber of Commerce. Your chamber's efforts to provide a forum for industry-government interactions, to promote international trade, and to guide policies to facilitate a conducive business climate in India and between our countries is truly commendable. We look forward to continuing partnering with you to strengthen and deepen US-India ties as our countries celebrate 75 years of diplomatic relations and trusted partnership. As Secretary of State Antony Blinken has said, there are few relationships in the world that are more vital than the one between the United States and India. We are two of the world's leading democracies and two of the world's largest economies, powered by the innovative spirit of our people. Together, the actions that India and the United States take are shaping the 21st century and beyond. That is why strengthening the partnership with India is one of the United States' top foreign policy priorities. As an Indo-Pacific nation as well, the United States is deeply aware of the importance of the region and US engagement here. In the words of Ambassador John Liu, our Assistant Secretary of State for South and Central Asia, the Indo-Pacific's future depends on the choices we make now. Our competitors are playing to win. We need to step forward in the United States with more resources, more high-level engagement, and most of all, a good plan. President Biden announced our updated Indo-Pacific strategy in February and laid out our government's vision for a free and open Indo-Pacific that is connected, prosperous, secure, and resilient. I believe that as we review this plan, you will see that many of the topics that you have planned to discuss in today's forum and summit very closely relate to this plan, and I hope that we'll be able to cooperate on it together. Our Indo-Pacific strategy will deepen the role of the United States in the region, and with our partners, build a collective capacity to confront 21st century challenges together. I would like to briefly walk through that strategy together with all of you. The first core objective is free and open, meaning people should be free in their daily lives and live in open societies. Individual countries should be able to choose their own paths and their own partners, and collective problems should be dealt with openly, rules agreed to transparently and applied fairly. And goods and ideas and people should flow freely across land, cyberspace, and open seas. Second, we want to increase the interconnectedness of the Indo-Pacific. With our partners, we are assembling the broadest, most effective coalitions to tackle global challenges and to work towards our shared goal. Secretary Blinken promised that he would find ways to knit our allies together with our partners, as we've done by reinvigorating the Quad, as Dr. Lalit mentioned earlier. Third, we aim for broad-based, inclusive prosperity. For the United States, this means increasing US investment at home and abroad, unlocking the potential of the private sector, and helping to deliver high-quality infrastructure. We are focused on economically empowering the middle class by facilitating trade, strengthening supply chains, and directing heightened attention to labor and environmental standards and clean energy. The Indo-Pacific Economic Framework will help us achieve these goals. President Biden launched the framework in Tokyo on May 23rd, and we are proud that India has joined us as a key framework partner, along with Australia, Brunei, Fiji, Indonesia, Japan, the Republic of Korea, Malaysia, New Zealand, the Philippines, Singapore, Thailand, and Vietnam. Collectively, These countries represent 40% of the global economy. Fourth, we are cognizant of our shared security challenges. As threats to security continue to evolve, we have focused our strategy on integrated deterrence. It's about reinforcing our strengths so that we can keep the peace, as we've done in the region for decades. We want peace and stability through a rules-based order in the Indo-Pacific. Fifth, we aim to help the region become more resilient, whether in the face of the next pandemic or dealing with the effects of climate change. Across the Indo-Pacific, people are feeling the catastrophic impact of climate change. 70% of the world's natural disasters strike in this region, and over 90 million people in the region were affected by climate-related disasters in 2019. We are leading efforts to bring the international community together to build greater resilience against future shocks. The key to the Indo-Pacific is India, and central to our Indo-Pacific strategy is supporting India's continued rise in regional leadership with economic, security, and democratic interests that complement our own. Today, the US-India relationship is on the cutting edge of almost every issue, from science and space to new and emerging technologies, and protecting against cybercrime, to combating climate change, to finding sources of clean energy, and protecting our oceans, and to expanding our trade. There is no area of human endeavor that we are not working on together. Trade and investment, of course, has long been at the heart of the US-India relationship. US-India trade has had a wide and lasting impact on our economies and societies, and that relationship has greatly expanded over time. The growth in our economic ties has been extraordinary, with trade surging from 20.7 billion in 2001 to 159 billion in 2001. Even as the pandemic has taken its toll on trade, the United States remains the largest trading partner of India, and India is the 9th largest trading partner of the United States. Most major US firms have made significant investments and operations in India, making the United States India's largest source of foreign direct investment. An expanding number of Indian companies have similarly found the United States to be a welcoming destination for trade and investment. US companies are consistently India's biggest source of foreign direct investment, as well as collectively its best partner. US investment has created more than 5 million jobs here in India, and those formal economy jobs also boost India's tax base and provide other benefits to the local economy. In addition to job creation, US companies also play a critical role through their unparalleled contributions in research and development, personnel training and development of local managers, and incorporation of Indian inputs into crucial global supply chains. But this economic relationship still has room to grow. We welcome the reconvening of the US-India Trade Policy Forum in November 2021 that focused on issues including agricultural market access, labor, the environment, good regulatory practices, digital trade, and standards. The meeting's tenor was positive and collegial, and the Minister of Commerce Goyal and his counterpart, United States Trade Representative Tai, agreed to convene working groups in the coming months to sustain that momentum and hold the next ministerial by the end of this year, 2022. We are also excited that this past October, the governments of India and the United States co-hosted the 2021 Indo-Pacific Business Forum, bringing together more than 2,300 businesses and government leaders to promote economic engagement and highlighting nearly 7 billion in new private sector projects. It was the first time that the forum was held outside of East Asia, and it demonstrated the key role of India and South Asia. On energy, which I know is a key topic of this forum, President Biden and Prime Minister Modi launched the US-India Climate and Clean Energy Agenda 2030 Partnership, committing to jointly invigorate efforts tackling the global climate crisis. To address climate change, Presidential Envoy for Climate, John Kerry, and Minister of Environment, Forest and Climate Change, Bhupender Yadav, launched the Climate Action and Finance Mobilization Dialogue, or CAF-MD, creating a new platform for bilateral cooperation on climate ambition, finance, road mapping, and adaptation. We're also proud to have joined the Indian-led International Solar Alliance, and the Coalition for Disaster Resilient Infrastructure that the United States will co-chair with India. The U.S. International Development Finance Corporation, or DFC, made a $500 million investment in First Solar to manufacture solar panels in southern India. On vaccines, under the Quad Vaccine Partnership, the DFC provided $50 million in financial support to expand COVID-19 vaccine production at Hyderabad-based vaccine manufacturer Biological E, or BioE. The agreement fulfilled the President's pledge to make the Quad Leaders Summit made at the Quad Leaders Summit in March 2021 to contribute to the production of 1 billion vaccines for the Indo-Pacific region by the end of 2022. As you can tell from my comments, the DFC is at the cutting edge of our engagement in India and the Indo-Pacific, focusing our climate, clean energy, healthcare, infrastructure, and sustainable development investments. India is the DFC's largest portfolio with 3.1 billion in active investments and 400 million more planned for the year ahead. The simple fact is that our peoples and our countries are closer now than they have been at any other point in history. We can see this by the continuous stream of high-level engagements between our two countries since the start of the Biden administration last year. I could list those all, but they are many. And I will simply say that it's clear from all that we're doing together as the United States and India that we share a common vision for the region, one that is free and open, secure and prosperous, and that our futures are inexorably linked. We look forward to continuing to deepen our cooperation with all of you as we advance prosperity, promote our shared democratic values, and bring the creativity and brilliance of our people together to solve the global problems of today and tomorrow. Thank you.
Thank you, Ms. Slova. I think it is always good to hear the official version of our relationship, and that also particularly from the representative of the United States Embassy. It was indeed very encouraging and heartening to note about the US initiatives along with India, and particularly US investment in infrastructure and promoting trade. You also spoke about our cooperation in the field of science, the information technology, space, climate, protecting oceans. And also you highlighted recent initiatives taken by Government of India, by various ministries, which involve, you see, US cooperation. So we are indeed very grateful to you for your participation and sharing with us, you see, the perspective of the US government so far as Indo-US relations and our 75 years of mutual cooperation. So our thanks to you and to the United States Embassy. Thanks a lot. And thank you. With that, we move over to one of our domestic celebrities, Mr. Shikhil Suri. Mr. Shikhil Suri is a dual qualified lawyer, qualified to practice in India as well as in the United States. Therefore, there could have been no one better than to speak on what his experience has been as a practitioner of law in the United States and then as a very successful practitioner of law in India also. He is a former chair of the American Bar Association section of International Law India Committee and currently serves as its senior advisor and is a member of the Indian Merchants Chamber Arbitration Committee and a life member of the Supreme Court Bar Association. So over to you, my friend, Mr. Shikhil Suri.
Thank you, sir. A very good morning and good evening to all, whichever part of the world you are in. Shri Tushar Mehta, the learned Solicitor General of India, Ms. Audrey Slover, Acting Economic Growth United Chief, US Embassy, Honorable Judge Sanjay Taylor, Dr. Basin, my co-speakers and attendees who have joined us today to celebrate 75 years of the India-US relations. When I was asked to be a part of this panel discussion, I was elated, thrilled, excited. I've had a long association with the legal system of the United States, having completed my master's at the University of Pennsylvania, and followed by practicing in Washington, D.C. and New York. But to the surprise of a large number of people, people were surprised when I decided to move back to India to establish my practice. But in hindsight, I do feel I did make the right decision. Having worked in the US and India, I've been able to get an insight into the working of the legal fields in both the jurisdictions. So I often find myself drawing parallels and distinctions between the two jurisdictions, deliberating with colleagues on the aspects which India could borrow from the United States and vice versa in order to make our respective systems stronger. So the forum today comes at a critical time, I believe. As many of you know, the US-India relationship has reached greater heights in recent years. I remember during my early years in the US-Indian civilian nuclear deal was a core pillar of the strategic partnership, the 123 treaty as it used to be called. Today, however, I feel the relationship has become extremely broad-based, as the previous speakers pointed out. It covers not just the economic, security, strategic, trade, and even technology-related dimensions. And given the recent geopolitical developments, I think the relationship has assumed even greater significance. I believe that if our two democracies are to offer the world a lasting vision for the next several decades, a commitment to the rule of law will surely be an essential component of it. So today, the topic that I've been asked to address you all is on rule of law, which is extremely important. So I've tried to structure my address in about 3 parts. The first part, I would, you all are very familiar with the concepts, the theories, so I'm not going to deliberate too much on that, but with a brief introduction on the concept and how India follows this. The second part of our discussion, which I think is very important, is what really, now that we have the rule of law established in both of our jurisdictions, what really are the key components, for upholding the rule of law. And I will submit that access to justice, or rather access to speedy justice, is a key pillar for upholding the rule of law. I also will submit that legal aid is critical in the Indian scenario for enabling access to justice. I will also discuss how it plays a role in bridging the gap between the citizens and their access to the judiciary. I will also provide you all with some insight, and I think that will be very useful for our friends from the US, on the strong legal aid base that we have from our legal aid authorities in India and the exceptional work I believe these authorities have done. I will also address the issue of pendency, which is a widely debated and discussed topic, and how we in India have been working towards addressing that. The third part of my address, time permitting, will also focus on the difference between the rule of law and rule by law. I will conclude my address by discussing the role of different stakeholders, the judiciary, the government, the lawyers and citizens in upholding the rule of law. And I will submit to you that maintaining the rule of law in my submission is a collaborative project, where participation from all stakeholders and beneficiaries is needed in order to make it a more robust and effective principle. So now let me delve very quickly into the background of rule of law in India. Since India is a common law country, it recognizes the rule of law. For us, the constitution is the core, the base, the authority from which all our laws are based on, and where we draw authority from. And you all are aware on the broad components of the rule of law: the supremacy of the law, equality before law, and the predominance of the legal spirit. All these are entrenched in our constitution in Articles 13 and 14, which you all are aware of. But more importantly, in this entire system, the Indian judiciary particularly plays an extremely important role, I believe, in upholding the rule of law. Like in many other countries, it protects the democratic values. The Constitution bridges the gap between the law and the society and attempts to ensure that social and economic justice is maintained and sustained. the key aspect I wanted to touch upon in my address is access to justice and legal aid in India as key pillars of rule of law. In upholding this rule of law, access to justice, I believe, is a key pillar, particularly in the Indian context. In fact, I'd like to quote the Honorable Chief Justice of India, Justice N.V. Ramanna, while he was addressing on the rule of law, said that one of the important components of equality before law is access to justice. He said, and I quote, "I must emphasize that in a democratic country like ours, access to justice forms the bedrock of rule of law. However, this guarantee of equal justice will be rendered meaningless if the vulnerable sections are unable to enjoy their rights because of their poverty or illiteracy or any other kind of weakness. In India, the Legal Aid Authority is estimated to serve more than 70% of the population who are entitled for free legal aid, making the Indian legal aid system one of the largest in the world," unquote. As a strong advocate of legal aid myself and handling cases on behalf of the Legal Aid Services Committee in the Supreme Court, I felt it appropriate to focus my address on especially on legal aid. Before I give you the figures, which I think would make all of this more contextual, will give more context to what I'm outlining. One concept I'd like to invite the attention of our friends from the US is the concept of public interest litigation. Though most of you would be familiar, but I would be remiss in not mentioning that as an important component of rule of law. In India, the weaker sections of society, due to their social and economic position, have for a long time unable to enforce their rights and fight against injustices. In this sense, their access to courts is limited. So acknowledging this, our courts have liberalized the concept of locus standi and introduced a new tool, if I can call it, to enforce fundamental rights. And our friends in the US would be pleased to know, I mean, this has a lot of parallels, by the way, to the Bill of Rights in the US. This new innovative tool is termed as public interest litigation. The Indian Supreme Court, departed from the traditional rule of locus standi and broadened the access to justice, and has worked and continues to tirelessly work to protect the fundamental rights of the poor and the marginalized. In fact, though it does come with a fair amount of caution, and the courts have been very cautious so that this tool is not misused. It should not be a private interest litigation or a public interest, a publicity interest litigation. So the courts have been very cautious as well. But this is one of the tools I wanted to highlight for our friends in the US. Now, coming to the topic of legal aid, I personally take great pride in saying that the Indian Constitution serves as an outstanding example for other jurisdictions. The state is obligated to provide legal assistance to those who cannot afford it. Article 39A of our Constitution, a directive principle of state policy, provides for equal justice and free legal aid. In fact, the Indian government has a constitutional duty to provide citizens judicial infrastructure and means to access justice. The legislature, while dispensing its duties under Article 39A, enacted what we call the Legal Services Authorities Act in 1987. Under this, they have constituted the National Legal Services Authority, NALSA for short, to monitor and evaluate the implementation of the legal aid programs. So to cater at local level, similar authorities are available at the state level, and then the district level, and at the taluk level. The entire apparatus of this legal aid is managed by our honorable judges. The Honorable Supreme Court has set up a Supreme Court Legal Services Committee to ensure that free legal aid services are provided to the poor and the underprivileged. And similar legal services committees are constituted in our higher courts and in our district courts. And I would like to just give you some figures from April 21 to March 22.
Yeah, Shikhil, 2 minutes only.
Yes,
Yeah.
has provided legal aid services to 6.3 million people, including almost 75,000 citizens in the month of April 2022 alone. So these figures indicate to you the reach of the legal aid program that has been now made available. Given the time constraints, I wanted to highlight a few judgments, but let me just take a couple of minutes to highlight a few landmark judgments that our courts have passed so that you could all have benefit. One is the Puttaswamy judgment of the Indian Supreme Court, where the right to privacy has been upheld as a guarantee under the Constitution. That is one judgment, I think, which you all would be very interested. The Supreme Court has also delved into matters of gender equality and justice. As an example, they've struck down provisions of our criminal code which made unnatural sex amongst consenting adults as an offense. They have recognized transgenders as a third gender and held that they should not be discriminated in matters of employment and education. And they've also advocated for equality in the army as well. In matters of personal liberty, the courts have intervened to protect the personal liberty of the citizens where custody is not required, and a number of criminal justice reforms have been initiated. As far as the role of the stakeholders is concerned, like I outlined in the beginning of my address, I think the three components, the lawyers, the judiciary and the government, all have to work together for us to have a successful implementation of the rule of law. And in the absence of one of them not working well, I think the concept would not be successful. And I mention all of these stakeholders also as a way to highlight the three tiers upon which the relationship between the US and the Indian legal communities must be built. So therefore, if the rule of law is a key pillar of the US and an Indian relationship, then the relationship between all these three stakeholders must be built. The lawyers, the government, and the judiciary of our two countries must build greater ties, whether intellectually, philosophically, judicially, to ensure that the primacy of these values that we believe in.
Thank you.
Thank you, sir. And to conclude, I would like to thank Dr. Bhasin, who's been a champion of the relationship between the Indian legal communities and the US legal community. And in fact, I believe and I respectfully submit that his is a life that is dedicated to advancing the rule of law amongst the legal and business communities, and I'm grateful to be a part of it. Thank you.
Thank you, Shikhil. You see, I changed the order of the presentations intentionally without seeking permission from Justice Sanjay Taylor, for the reason that I wanted to hear what Shikhil has to say on rule of law, so that the judge can have the final word. You see, because yes, on paper, whatever Shikhil has said, that is in place. We have the legal aid system, we have, you see, on paper, the rule of law, everything is there. But the same Chief Justice, which you see the quotation which Shikhil read, also said that we have nearly 5 crore cases which are pending. 5 crore would be, I think, I don't know, in millions, possibly 50 million or something more than that. 5 crore cases are pending in India. So where is that access to justice when the citizens, you see, do not get justice in a speedy manner, in an expeditious manner, in a non-expensive manner? Therefore, what needs to be done is where the government has to take a lead, because we have too many laws, obsolete laws, laws dating to 1800 something, early 1900s, very ill-drafted laws, obsolete, totally overlapping laws. So the citizens, you see, they do not get the justice. Therefore, on paper, yes, our constitution provides of all the safeguards. But what about the implementation of the provisions of the constitution? That is where we seem to be lacking in effort. And I wanted to hear Judge Sanjay Taylor on what can be done, if at all it is possible in India, to make it possible for our citizens to get justice, because the emphasis now has shifted from justice to law and the legal technicalities. Justice has taken, you see, a back seat. Although in the preamble of our constitution, we say to secure to the citizens justice, social, economic, political. But is it forthcoming? Yes. I'm very happy to see that the government has initiated certain steps. Firstly, about rationalization of laws. About 1,400 laws have been already obliterated from the statute book, and about 1,800 laws are under consideration. So that is where something may emerge out of it. But at the same time, we should not have new laws coming in, because new laws bring in new regulators, new disputes. Good for lawyers, but bad for the country, bad for the economy. So that is why I shifted, you see, the presentation order to have some views from Judge Sanjay Taylor, whom I introduced earlier as someone who has got 82% electorate vote, you see, for holding this position which he is having today. So over to you, Honorable Judge Sanjay Taylor.
Thank you. I've listened very closely to Mr. Shikhil Suri's arguments this evening, and I must tell you that I'm thoroughly persuaded and convinced by the points he has made that the rule of law is really dependent upon access to justice and timely justice. And so therefore, I am entering judgment in your favor, Mr. Shikhil Suri. And I am, let me just say I'm delighted to join you this evening. And I'd like to also recognize the honorable guests on the virtual dais and the friends who are attending and watching this evening. And of course, my good friend, Dr. Basin Lalitji, who I've known for well over a decade now and have very fond memories. You know, the rule of law really is such a broad topic that we could probably spend a semester on it. It's something that really depends on the where you live, the form of government that you live under, and you know, there's some countries where they will say that there's strong traditional rule of law, but there's not much substance to the laws in that country. For example, there may not be civil rights protections, and therefore, yes, they may follow the law, but that only goes so far. And I think, you know, if you ask most Indians, ask most Americans, they would not find that to be a strong tradition of rule of law. I think if you look at the Indian Constitution, it's one of the most progressive governing documents that has ever been crafted by and enacted by man. And so the challenge, of course, is how do we enforce it? And even when those laws are enforced by judgments of the court, will the judgments be honored by the people? Will they, even though they may disagree, will they abide by the law? And you know, it's something that judges constantly ask themselves, and that is, when I enter a judgment, I'm not writing for the winning party. I'm not writing for the Supreme Court. I'm not writing for the public. I'm writing to the losing party. And why I'm doing that is I need to tell them that I've considered their arguments. They need to know that I understand their arguments, that I've wrestled with the arguments and make sure that I explain why I have rejected the arguments. Now, I may not convince them of the merit of my position, but at least if I convince them that I listened and I explain, that they will then live with it. And that's really what, you know, rule of law comes down to. I think any discussion of the rule of law, at least from the United States perspective, you know, has to include what happened in the wake of the 2020 presidential election. As you all know, the incumbent candidate lost decisively in the popular vote. He also lost decisively in the electoral vote. Yet he put forward a narrative that the election was stolen. This narrative is false by every count. Yet it was a narrative that was put forward even before a single vote was cast. And you saw what happened with the attack on our US Congress. We have a committee investigating the events of that day and leading up to that day and what happened afterwards. And slowly, as more and more information comes out, it's become very apparent that our democratic system was under attack. And but the good news is that the rule of law prevailed. Yes, the electoral vote count was delayed. It was not postponed, however. It took place a couple hours later. And at the end of the day, the Constitution prevailed. I'm also reminded of, and I think Lalit, Dr. Bhasin mentioned the visit of the US delegation from the American Bar Association in 2009, which was in just a couple weeks after the 26/11 attack. And, you know, Dr. Bhasin had reached out to our group and said, you know, you might want to consider postponing your trip in light of, you know, what's been happening in India. And our leader at the time, Mr. Shieldhouse, who was the chair of the ABA section of international law, wrote back and saying, and he told Dr. Bhasin that, no, today we are all Indians and we will be with you because we stand for democratic form of government. We stand for rule of law, and this terrorist attack will not take hold. And so I think that's an example of how India and US are partners in the global struggle for human and civil rights. You know, one of the aspects of rule of law is, of course, judicial independence, and that includes both institutional and personal independence. Here in the US, you know, we have a US Supreme Court that's appointed by, whose members are appointed by the president and confirmed by the Senate. It's a deeply political process, as you've seen in the last couple appointments. And the court has taken a shift to the right, become much more conservative. And as a result, you're seeing judicial precedents that have been in place for a long time being overturned. This is something that I know causes the Chief Justice of the United States to stay up at night. He is at pains to point out to Americans that the US Supreme Court is not a political body, yet that's pretty much how it's viewed. And, you know, I don't know how the Indian Supreme Court is viewed, but it's a challenge that any system has. And so I think that really the rule of law comes down to two things that we as lawyers and as judges cannot disregard, and that is access to justice and timely justice. In our courts in Illinois, you know, unlike the Indian Constitution, which provides counsel as a matter of right to a litigant, we don't have that in civil cases. We have that in criminal cases, Gideon versus Wainwright. And I know the ABA has long been an advocate for what's called civil Gideon, that is to provide appointed counsel in civil cases. We don't have that. There's not a political will to fund such a system. Yet we do other things. You know, we do help desks. We do electronic websites where you can get help. We have legal assistance agencies. So there's a lot of different approaches to the problem, but yet our needs are not fully met, and that's a challenge. a full 50% of litigants in our state courts are pro se, that is, they represent themselves. And of course, they're always looking to the court for help. And I, as a judge, cannot provide one-side help. That's not the proper role of the court. So that's a constant challenge for us. The other challenge is timeliness of disposition. And one of the things that's very new in our court is our Supreme Court of Illinois has imposed time standards upon trial judges. And so they have looked at the various types of cases, and for each particular type of case, whether it's a tort, a contract action, any criminal action, a divorce, whatever type of case is, they've looked at the data. How long does it typically take for this kind of case to be resolved? And they've set time standards for these cases. So for example, 75% of divorce cases shall be resolved in 12 months. 98% shall be resolved in 18 months. And then, so that leaves the small 2% for the outlier cases, because there are always outlier cases. So I know the pace of justice is a big issue in India. Dr. Bhasin was mentioning that there are a similar number of lawyers in India as there are to the US, yet, our population is 300 million and Indian population is 1.3 million. The number of judges we have per capita is far greater than the number of judges that the Indian government has per capita. I will tell you that for many people I know who are NRIs, non-resident Indians, it's remarkable how we have a very similar experience involving the Indian legal system. My father had a land dispute. He passed away. I've inherited it, and I fear that my son will inherit it. And that's something that I know is a constant challenge and struggle for the Indian legal system. So, but it's an issue in the U.S. as well, and so we'll see how these time standards go. I'm hopeful. I'm also very hopeful about the rule of law. I know that I'll share with you that over the last couple of months, I was going door to door knocking because I was a candidate. And one voter said to me, Judge Taylor, isn't this beneath you to have to go door to door? And of course, I don't want to disagree with the voter, right? But I said, that this is the system that the Illinois Constitution establishes for selecting judges. It's by popular election. And the other thing I said is that democracy can never be beneath any of us. And I think that, the voter understood and appreciated it. So the other thing is there is a very large silent majority in the US who are very concerned about protecting our democracy. I saw it every single day when I was out there on the campaign trail. So I'm very hopeful. We're going through a period of a tumultuous period with respect to our democracy, but I am confident that the rule of law will ultimately prevail. So thank you very much for your time and listening.
Thank you, Honorable Judge Sanjay Taylor. The last point you made was very interesting, that we may follow different systems or different modes, say for instance of appointment of judges, but that does not take away from the merits that we all believe in the rule of law. Therefore, electing judges in the United States is a part and parcel of your democratic system, whereas in India we have the collegium system, which has worked very well till now, and the judges by and large, they have ensured that there is no dilution so far as the rule of law or the liberties of people are concerned. And rule of law would prevail, but the problem that we are having is, which you also pointed out, that access to justice has to be made more meaningful. And that is where the government has to take the initiative, the judicial system has to take the initiative, the legal profession has to take the initiative, so that there is no inordinate delay in the disposal of matters. Even as you say in United States, your aspirations so far as pro bono work is concerned, the challenge is not fully met because there is an increasing need. But that is nothing as compared to the problem that we have in India. But one good feature you pointed out, that the Supreme Court has laid down certain timelines for resolving the disputes. I think that is very crucial, because if that thing happens in India, although it is not the court, but several enactments provide for disposal of matters in, say, 3 months, 6 months, 12 months, but still those are not adhered to. They cannot be adhered to because of lack of proper infrastructure, including lack of number of judges, where you see we are failing miserably. The vacancies are not filled. So thanks for your very frank evaluation of the system which exists in the United States. But we do hope that our mutual cooperation so far as strengthening of the rule of law is concerned, that will continue. These are just certain hiccups which I'm sure, like the pendency of cases, which I'm sure with the initiative being taken by the present Indian government, these things will also be handled appropriately. So many thanks for joining us and sharing also with us your commitment and your comment that you decided to visit India at a time when we in India thought that it may not be safe for you to travel, but still being believers in rule of law and wanting to share, you see, our concern and our fears and whatever it was, you came to India, and it was one of the most successful visits. So many thanks for that. Now we have pleasure in moving on to our next speaker, Ms. Lisa Sevit. She is partner, the Axelrod firm, Washington, and she handles international and domestic litigation and alternative dispute resolution, representing foreign and domestic companies. She is, more importantly, a former chair of the American Bar Association section of International Law and currently serves on the ABA Rule of Law Initiative Board. Interestingly, she is also former chair of the International Committee of Direct Women, a national non-profit that works to increase the number of women lawyers on the corporate boards. She is also chair of the board of a non-profit organization known as A Child for All, which helps vulnerable children in Mali. So it's a great pleasure and privilege to have a bar leader of the status of Lisa Sevit to address us and to share her views on the perils of the climate change and the responsibility of the legal profession. So over to you, Ms. Lisa Sevit.
Thank you, and it's an honor and a pleasure to join all of you, and thank you, Dr. Bastine, for inviting me, and it's just great to reconnect with old dear friends. You mentioned the nonprofit Child for All, and I was thinking of what Shikhil talked about with access to justice. We're actually, our organization is a recipient of a scholarship from an American Indian nonprofit that helps tribal and slum girls in India and now in Mali to develop confidence and teamwork through scholarships to join in sports. So there's a lot of connections still. I also, thank you, Judge Taylor. I mean, your connection between perception and reality, that is something that is also evident in climate change, although I really think that today perception and reality are merging into one. So I preface these remarks by stating that I'm not a climate change lawyer, but I will end these remarks with the admonition that we all should be climate change lawyers. So we all know by now the perils of climate change. Just this week, we've seen the record high temperatures in Europe, increased rainfall and flooding and severe drought in the United States and around the world, wildfires and tornadoes in locations which never previously had this kind of weather. The glaciers are melting, causing accidents to hikers and skiers. We are losing borders. For example, the Rio Grande defined the border between US and Mexico, but it's drying up now. So how do we define the border? What if it's too hot for planes to take off? How do you get your Federal Express package where it needs to go to meet a deadline, whether as an individual or a lawyer? Nuclear reactors can't run as water is too hot to use. Anyway, I don't have to detail all the circumstances of climate change, but, and certainly as individuals, we have a responsibility to do what we can to combat climate change. This includes everything from sorting out our rubbish, switching to electric or hybrid cars, and conserving water. As individuals, we need to amplify to others how important it is to change their habits. I recently moved to California, and my husband every day tells me, you're using too much water, and don't forget to put your plastic in one place and your rubbish in the other. So it's a learning curve, but we all should be learning it. And what of the legal profession? What can we do as lawyers, as bar associations, as advocates, and as counselors for our clients? John Kerry, who was mentioned previously, and he is the US Special Presidential Envoy for Climate, has admonished the American Bar Association to consider that all lawyers are climate change lawyers now. As advocates, we advocate for our clients, and some of us who do litigation have the skills to do so forcefully. We all argue forcefully for our clients' positions. Now, we must advocate about this existential threat to our planet. We must also take care of and anticipate the needs of vulnerable populations who are already being affected by climate change, including the poor and the elderly. Homelessness is increasing in the United States. It's really incredible how much you're seeing it in cities and even in small towns. And around the world, climate change is forcing an ever-increasing number of people to leave their homes and their countries and to become refugees. If you do family or elder care law, or trust in estates, or even real estate, it is time to take climate change and its effects into consideration on the advice that we give. For example, what if a client lives in a potential now flood or wildfire zone? How does it affect the purchase or sale of property? How does it impact potential estate assets? What insurance advice can be relayed? How is this climate change affecting trade? How is it affecting our children? We've seen the pandemic's effect on education and health. Climate change is posing the same threat. So again, if you counsel or interact with families, with clients, climate change must be a consideration in the legal advice you provide. I'm turning now to bar associations. So in 2019, the American Bar Association adopted a resolution on climate change. In that resolution, the ABA urged both government and private sector to recognize their obligation to address climate change and to take action. The resolution also urged Congress to enact climate change legislation and for the US to engage in international efforts to address climate change. Unfortunately, politics, as always, comes in, and we haven't really gotten very far in terms of congressional climate change legislation. The resolution by the ABA also asked lawyers to engage in pro bono activities related to climate change and to advise clients about the risks and opportunities connected with climate change. The resolution is also specific, stating goals, including reducing U.S. greenhouse gas emissions to net zero or below, consistent with latest peer-reviewed science, and also to provide a just transition for the people and places most dependent on the carbon economy. In 2020, so a year later, the Law Society of England and Wales also issued a climate change resolution. This resolution resolves to develop plans and to take rapid action. It resolves to support solicitors to be fully informed on how they might act to mitigate the climate crisis. It provides guidance to solicitors on how, when approaching any matter arising in the course of legal practice, to take into account the likely impact of that matter upon the climate crisis in a way which is compatible with their professional duties in the administration of justice. The Law Society resolved to develop and disseminate educational tools and resources to support solicitors to incorporate into their daily practice advice on the impacts of climate change and to prepare for the likely impacts of climate change on their daily practice. It also admonished and encouraged engagement with current and future climate change related legislative, regulatory, and policy reform, so far as it impacts on the practice of law, access to justice, and the rule of law. The Law Society also stated that we must influence the regime governing legal training and education on issues pertaining to climate change, and lastly, to collaborate actively with others for the greatest impact in addressing the climate crisis, including clients, regulators, other bar associations, other professional bodies, and legal networks focused on ameliorating the climate crisis. So I looked at these resolutions. I was aware of the ABA one, excuse me, and they're good. But what has been the effectiveness of making all this happen? Right now, we have in the United States, many states that have continuing legal education requirements, not just on legal topics, but also, for example, on diversity and mental health issues. And maybe other colleagues on this Zoom call have seen this, but I have not seen much, if anything, on CLE requirements on climate change issues. I believe that this should now be, I mean, we don't have time anymore, something that should be required to educate lawyers on climate change and how it affects people and the legal profession and how we can help. So as advocates and as bar associations, we can have impact on legislation. We also should be supporting the requirement for financial institutions to report on the material, environmental, economic, and social impacts of their investments, and if need be, through the legal instruments that we guide for our clients. So what about corporate counsel? At the World Economic Forum, it was recently pointed out that at least 1/5 of the world's largest public companies have committed to net zero targets, and for many with the focus gone beyond their own emissions. Major companies are in a prime position to not only pay attention to climate change, but to innovate, finance, and install technology that the world needs to deal with climate change. Businesses and their actions make a strong impact on the environment, and general counsels and legal departments should be on the front lines of climate change. General counsel and in-house counsel generally are key allies to the board and chief executives in setting their company's ethical tone from the top. Thus, the legal department in a company is an indispensable contributor to corporate sustainability efforts, not just like green issues, like reducing a company's carbon footprint, but in governance, their operating practices, and in their own internal dealings. So we as lawyers must not just point out the risks of dealing with climate change, but we also should point out the opportunities. It has not been lost on law firms that touting their green offices was good public relations strategy. It is the same for companies, but it must be true. Branding a company as climate conscious is good business just on a superficial level, but it must go beyond this. Companies, including law firms, besides being champions for environmental sustainability within their own companies, can also require vendors they deal with to have sustainability requirements. So some of the examples of what we as lawyers can do, we can make sure that our clients are on the cutting edge of climate change and other sustainability issues. We can make sure they are looking at green building financing and construction standards and practices, that they're looking at renewable energy, mitigation for new and expanding industrial, commercial, and residential development projects, sea level rise, and more. As general public demands action, we also need to be advising our clients to make sure they're compliant with all regulatory laws. We can help our clients be creative and forward-thinking, such as with the creation of mixed-use development, transit and pedestrian-oriented neighborhoods, and the preservation of open space. Basically, anything which comes across our desk should be reviewed with a climate change lens. Although I've not handled matters in climate change litigation, there is a need to be aware of this aspect of litigation. For example, there is increasing litigation by advocacy groups against governments and companies. What if a client is denied permission for wind turbines, or faces loss of productive land, or has to give up development of realty because of efforts to mitigate potential water issues? Financially, what litigation might we see out of the recent heat wave, where train companies and airlines canceled services? What is all the climate change issues doing to our already aggravated supply chain? What does climate change do to investment decisions? Coastal developments which become uninsurable as they are ill-equipped to withstand rising sea level, storms, and floodings. These are all things that we should be thinking of and advising our clients about and learning about how to deal with this. So I wanted to talk really quickly about another area that climate change affects, and that's in disaster preparedness. So we as lawyers, our counsel is often sought when it comes to disasters as well. And there are many organizations now that are being formed, companies, to deal with disaster around the world due to climate change. One that I'm familiar with is called Airlink. It's a very recent company. It's a nonprofit, actually, that developed to connect nonprofits on the ground with aviation assets around the world to partner together to get resources, both technology, personnel, to where there's been a disaster. And they get this through, it's a nonprofit, they get funding through grants. So for example, when there's a flood that affected anywhere in the world, they will approach, for example, United Airlines and said, we need to get some resources. We need to get firefighters. We need to get trucks. We need to get whatever it is to that disaster area, which obviously is not easy to get to because of the flooding. And they literally, it's called Airlink. They link the nonprofits on the ground with the airline who provides space and donates space to get the resources needed to the disaster area. Very recently, this company received a very large grant to do this work, but you're going to see more and more organizations popping up to deal with the climate change issues that the reality that we've dealt with, never dealt with before. So back to the topic at hand, the perils of climate change and the responsibility of the legal profession. Now, not later, is the time for us to become educated on this topic and to take action. Thank you.
Thank you very much. That was a very illuminating, educative, informative address. You very rightly highlighted the responsibility of the legal profession to deal with the issue of climate change. And I like the slogan which you quoted John Kerry to give, that all lawyers are climate change lawyers. I think that is so true, so important, keeping in view the impending disaster if steps are not taken, timely steps are not taken. You also pointed out the need to educate lawyers on climate change and also the role of the corporate sector, and particularly that of the general counsel and in-house counsel in advising their respective boards of directors about the perils of the climate change if immediate remedial steps are not taken by those corporate bodies. Therefore, there is a big responsibility on the general counsel and corporate and the in-house counsel And finally, you also spoke about the disaster management preparedness. In India, we are taking steps because there have been a few instances where enormous loss of life was also caused, but steps are being taken, and we have a legislation in place so far as the disaster management is concerned. But many thanks for sharing these views, not only from the US perspective, but I feel it is from a global perspective. Now, with this, I have great pleasure in moving on to the Indian speaker on the subject, that is Mr. Sanjay Nautani, who is a senior partner at the ELP, that is the Economic Laws Practice, and he co-heads the International Trade and Customs Practice. He has advised businesses and industry associations on a wide array of issues related to SPS and TBT, that is non-tariff barriers. And he has been recommended for his expertise in Chambers Asia, Chambers Global, and many other organizations, and is recipient of many awards. So I have great pleasure in presenting to you Mr. Sanjay Nautani.
Thank you, Dr. Bhasin. First of all, I would like to thank, of course, Dr. Bhasin, IAC, Jaipur Jain at the ABA, who have been, giving me my mentorship on climate change. And of course, it's a pleasure to be amongst the presence of honorable speakers and friends on this group. Given that my profession, of course, is on international trade and customs, which we can all see has moved purposefully, where we used to be on, living on topics such as physical goods. Today, it has now moved to contemporary issues such as digital trade, climate change, human rights, labor, and, all of these issues. Very quickly, I've just made a very small presentation, which I would like to give. First of all, words of our father of nation, Mahatma Gandhi: earth provides enough to satisfy every man's need, but not every man's greed. And I think it's important in the context of climate change, the way today we look at it. I've divided the topic on the basis of, what are the global and India focused policies, some of the litigation updates, and last but not the least, the legal profession and the next steps. Ms. Lisa Sevit has already sort of touched upon what exactly is climate change, and I wouldn't be sort of laboring my time on it. But of course, this week's European fires, which we have seen how it has affected not only Europe, but ultimately the fires and people, clearly is enough evidence for all of us to see how climate change is clearly affecting all of us in our daily lives. The international framework is clearly there in terms of all the clean development mechanism, joint implementation, Paris Agreement, Article 6 of the Paris Agreement, which requires all of us to follow these particular forums and standards on climate change. Ultimately, who can fix it? And this is an interesting topic because it's the governments who make laws and policies. It's the courts who will play the pivotal role to compel governments and businesses to respect and accelerate commitments on climate change. It's the businesses which will have to change their processes to run more sustainably. Legal education, which of course Ms. Sevit also picked, and I completely agree with that the young lawyers need to engage early in learning and adapting. And last and not the least, all of us will have to make choices in our lives that reduce our carbon footprint. Now, this slide is particularly very interesting given that it sort of talks about, the global overview on trade and environment. And you can see, from the slide that how, the number of notifications and measures at the WTO, which has been filed by members, talk about affecting products, affecting various things on climate change and protection measures. The top three sectors which have been affected is the agri, the manufacturing, the chemicals. And of course, India's position remains 23rd on this. We are the third largest polluter in India and in the world, and highest carbon intensity in electricity in the world. So, you can see from this that there is a great activity which is happening at the WTO on all of these issues, which is a matter of concern. And I think we need to, resolve this as early as possible. These are the 6 climate positive actions which have been framed by the UN. One is the green transition, which is very important because investments, finance, these are the topics of debate, not only for now, but will remain for the next 2 to 3 decades as to how we need to sort of accelerate and how we need to get to exactly what we have claimed to be the net zero. Green jobs, very, very important for all of us. Green economy, investment in sustainable solutions and finding technologies, confronting all of us on the climate risk, and last and not the least, cooperation, because no country can succeed alone. And that's absolutely very, very important for all of us. Some of the areas of policy making which has been, popularly voted by people around the world on issues such as conserving forest land, renewable power, climate-friendly farming, green jobs, and last and not the least, electric vehicles, where there will be a lot of action which we have to sort of, work around. And this is very, very interesting. These are certain sort of parameters which we will have to follow, both in terms of as we start working on what our commitments is. It requires a lot of assessment, understanding, and reporting of these restoring actions, because ultimately we all sort of not only are responsible for our own act, but ultimately it's a concerted effort for us to see how exactly we are going to sort of, work on some of these things. Focus areas of policy. And I think as far as the focus areas of policy, the first and foremost, I think it's very important that the R&D, which is the research and development, is important not only for a country like India, but globally. And I think it's important that we absolutely work towards making investments. Ultimately important that, not only the right investments are made in R&D, but actually these are, shared globally with the rest of the community, because ultimately all of us investing in the same R&D will never make, both financially and viability a lot of sense. So it's important to get into that. Imposition of environmental taxes. I think that's also important for polluting industries. However, there are legal standards, but if there are any industries which are breaching, I think it needs to be taken with a very serious task towards it. Strengthening existing environmental agencies. And I think that's important not only from a regulatory perspective, but also it is important from, judicial actions. Environmental agencies have to be now start becoming responsible for education, research and development, and policy for promoting sustainability. Last and not the least, transportation policies, which we are already seeing on the ground, but ultimately will need a lot of action to see how green logistics, green lobbies, how rail transport, all of these are working in tandem in order to ensure that the supply chain remain absolutely responsible and clear. Policy development, carbon taxes. Interestingly, we are seeing that a carbon tax explicitly states a government generated price on greenhouse protocol emissions. India has, of course, taken several steps towards reducing carbon footprint. However, there is no central regulation levying carbon taxes in India. But however, we are seeing Europe is coming up with certain policies which will ensure that, how if any of these products are crossing borders, how exactly there will be penalties in place to ensure that, such kinds of products do not sort of enter anybody's country, and exactly, those are policies towards it. The emission trading schemes, again, one of these things will start becoming very important, because as well as how we start decarbonizing ourselves, there will be a lot of things around us for this. Subsidy on electrical vehicles, already India has put in place some of these subsidy schemes, which will ultimately help us to, very quickly move towards becoming sustainable or as far as green on electrical vehicles is concerned. The path forward for India, agriculture. Agriculture in India creates 16% of emissions, and rice cultivation is a major source. Now, what is the solution towards it? The solution is, improved hybrid seeds to increase yields. And the recommendation, therefore, is reduction of tariffs, ultimately, which will help us to, reduce some of this. As far as industry and manufacturing is concerned, MSMEs in India almost are part of 30% of the GDP, but unfortunately, they are also considered one of the highest polluters because of the kind of investments they need. And ultimately, it is important that, installation of some of these energy efficient equipments are made available to these marginalized parts of the industry, which, will go in a long way to sort of promoting green. As far as green buildings are concerned, again, very important. We already have the mandate for it. However, there is a lot of discretion which is still available within states, which India will have to sort of ensure that it's done in the right and purposeful manner. And last and not the least, the transport. A lot of projects are happening around the world, including India. And I think it's important that there is a dedicated freight corridors, which projects are done on a priority basis. And ultimately, we get to the best of how we sort of promote this. This topic is, of course, been very talked about, interesting, ESG, and I wouldn't sort of labor too much about it. But the question which comes to our mind is, how are we going to be dealing with some of these issues? Because as ESG investing becomes more mainstream, what we are getting to see is the disclosure requirements need to pace with this change, while companies have been facing increasing pressure from investors and other stakeholders to disclose their ESG risk. However, there are practices and impacts. Regulators around the world are increasingly requiring ESG disclosures. However, we need to evolve international interpolarity on some of these regulations between government to government and stakeholders such as MNCs, banking and financial institutions, because there is a lot of confusion over this, and ultimately we need to resolve it in the right manner. This is, of course, India's commitment, which we are really working on, and India has really invested a lot of good policies, including investments in green energy, which we are actually on track to meet with some of our commitments. Now, let me very interestingly touch upon the global and India landmark litigations, because it's important. The Bank of England has identified some of these litigations across the globe, which is the direct causal contribution violation of fundamental rights and the greenwashing claim. Let me lay some background onto this. The research shows that 2015 was a very pivotal movement for climate litigation. And it was then the Paris Agreement came in 2016, wherein 190 states agreed to keep global warming well below 2 degrees relative to the pre-industrial levels while aiming for 1.5. Litigations on climate have doubled since 2015. And as it stands, based on some statistics, we have about 1,841 cases identified across jurisdictions around the world since 1986. And out of that, 1,006 cases have been filed only in 2015, after 2015. And this pretty much shows that, how, lately these litigations have become very, very important on the climate change. And in 2020, almost 40% of these cases have been filed. And I think it's important that we understand the need of these things, including certain other litigations which have been identified, in terms of how pretty much the growing risk to the corporate world has not escaped the notice of the authority. And this is why some of these litigations are very important, and also to the extent of the effect of the cost and liability of directors' liability insurance on some of these things. Because if real world cases lead to payouts, the possible financial costs that can only be borne by businesses or insurers are large. And therefore, this is important that we take into consideration some of these. Now, coming very quickly to some of these landmark cases, and I think it's important to.
Sanjay, just 2 minutes more, please.
Yes, sir.
Yeah.
Important that, these are some of these landmark cases which have happened. And ultimately, very, very clearly it shows that how, from these cases, what is to be learned not only for India, but for the world, because some of these litigations are going to cross, internationally, because a lot of learning comes from some of this, that how governments as well as private entities, including all of us, are responsible to learn from this and teach actually to the corporates, and corporates also have to be responsible around it. Some of these cases are there, and what I will do is, with the permission of Dr. Bhasin, we will circulate this presentation, and it could be useful for all of you all. This is another case which is one of the Shell cases, where actually the court was asked, the court asked Shell to reduce its emission by about 45% by 2030, and these are some really landmark cases. I'll spend almost only a minute on this. This is one of the ongoing cases, interestingly, where it's a transnational case, wherein a Peruvian farmer has filed a case against Germany because the German largest electricity producer was one of the companies, based on research, was showed that ultimately they were responsible as the effects on the glaciers which were happening. And this is absolutely an interesting case which we should be looking at very closely, because ultimately how the effect from certain country and the cause and the effect will be looked by the German courts, and ultimately this will affect. These are some Indian cases, and I will not spend too much time about it.
Yeah.
Last and not the least, as all of us, policy initiatives are important, education is important, energy efficient and low waste measures for offices are important, ESG is important. Last and not the least, the young lawyers or the young people are today very smart. Ultimately, it's very important that all of us, follow everything as far as the green is concerned, because, today they are what they are, and, one of the pretty much rising stars and the Gen X of the world clearly want. Of course, this.
Thank you very much. Thanks a lot, Sanjay. Thank you.
Thank you, sir.
If you share this with us, we'll have it circulated to not only the speakers, but also to the participants. You have very rightly highlighted, you see the 6 initiatives of the United Nations and the focus areas of policy investment, particularly in the in R&D and subsidiary to the electric vehicles. And when you were talking about the path forward in the field of agriculture and MSMEs with reference to India, I think these are very, very relevant points, as also with regard to the green buildings. And you highlighted, you see the litigation, and particularly the last one, Luciano's case in Germany, very relevant. So I think we'll all benefit if you have this shared with us, and we will circulate the same. Thanks a lot.
Thank you, sir.
With this, we move on to someone who is virtually and actually a bar leader, and bar leader not just known in the United States but also in India. That is Mr. Jaipur Jain, who is partner in Lazare, Potter, Devios and Moyle LLP. He represents domestic and international technology and other clients in corporate, securities and commercial transactions. His practice focuses on mergers and acquisitions, private business entities, private securities. That is all his professional achievement. But other than that, what is it that he's giving to the lawyers and the legal professions and the Bar Association? He's a life fellow of the American Bar Foundation, a member of the Attorney Grievance Committee of New York, First Department, a member and secretary of the Board of Directors of the Association of the Bar of the City of New York, chair of Legal Practice, Ethics and Delivery of Legal Services Division of the American Bar Association International Section, and chairman of ABA's South Asia, Oceania and India Committee, a role which he has performed to perfection. and we are proud to have him as to chair. And he also co-chaired the ABA International Annual Conference in April 2022. And he's got many publications and presentations to his name. So it's a big honor for us to have Mr. Jaipur Jain to share his views on what can be the role of the bar associations and chambers of commerce and the legal profession, you see, so far as the legal services sector is concerned. Over to you, Jaipur ji.
Namaskar, Lalit ji. Sanjay, as always, pleasure to hear you. Lalit ji, you have been very kind in giving details from my profile. I have known you long enough to know that when you frame a program and what might appear as disparate topics, you have a deep purpose in mind. And as far as climate change is concerned, you encouraged the committee to take that as a topic for the ABA South section of International Law Annual Conference. And with your assistance and guidance, we did that. And we brought the speakers from US, from India, from UK. And I'm glad today I'm here with Sanjay, who played a very important role in co-chairing it. But when you chose these three topics for today, rule of law, role of lawyers in economic cooperation, and climate change, it is obvious to all of us. Rohit Kochar and Tushar Mehta ji and Judge Taylor, Shikhil, all of us, Lisa Sevit, all of us spoke to the various dimensions of it, but it is very clear what you had in mind. You realize how important climate change has become, and you understand that the way to effect climate change policies is to follow the rule of law and to compel all of us, especially those of us who are engaged in trying to advance economic goals. And one of the concept of economic goals has always been growth. So all of us who are trying to advance growth have to be mindful of engaging in our activities so as to protect our environment and within the framework of rule of law. The third element which you included was the role of lawyers. And I think this is probably the most significant addition or combination that you have made, because we have seen, and Judge Taylor made a reference to January 6th and rule of law issues, even in countries like the United States, which we all looked up to and still look up to when it comes to the idea of rule of law. You have purposely put this thing together because you are trying to emphasize the role of lawyers, that the legislators haven't succeeded in creating all that we wanted them to do, whether it is the US Congress or the Indian Parliament. We are beginning to realize that there is an acute need, particularly in India, for emulating how lawyers have come to play a very significant role in drafting laws. And in this respect, you have particularly asked us to speak about the role of organizations like ABA, SILF, Chambers of Commerce. And I think in this area, I can talk about the lessons that I have learned in the course of my practice of law and being a part of various bar associations. So when I came to the US, I was an international trader. This goes back now more than 2 decades. And at that time, we used to say that ships follow the goods and banks follow the ships. Now I have come to realize that lawyers follow all of them. And lawyers also follow other lawyers. And we are particularly good learners when it comes to what laws work and what don't work, whether it is a strategy at a court, what strategy works or what doesn't work, or it is a law which has been implemented or a practice which has been implemented elsewhere. We improvise on them. It is part of our DNA. No wonder we copy forms also. So we often see that lawyers believe in the practice of law, and as practitioners, we look to successful models. And when we see successful models, we try to utilize them, we try to improvise on them. And in the case of India, we add our special touch to it, which is called Jugaad. So over the years, I noticed as a trader that while when I was in India, we were often struggling with basic issues and going to courts on basic disputes. After I came here, I realized that many of those disputes, for instance, disputes related to customs and trade, which I know Sanjay does, were a very important part of what I did as a trader and running an entity in New York, which was engaged in trading. But I realized in New York that those disputes really didn't exist. The type of disputes I was facing was very different from the type of disputes I was facing while I was in India. And why did that happen? That happened because in the US, we had over a period of time integrated, starting with the law merchant, the customs and practices and usages of trade, and made them part of our laws. So we have the Uniform Commercial Code, for instance. Similarly, at the international level, I found that how UCPDC came about, the Uniform Customs and Practices for Documentary Credits. It are not a combination of national laws. It is merely putting together uniform practices and usages, which means how, and they have become the foundation today of all international trade. So any letter of credit is not done on the basis of a law, but it is done on the basis of codified uniform practices. That's how Incoterms came about. And the beauty of that, I saw it firsthand when I became a member of New York City Bar Association. And there are certain laws in New York. One of them is in the securities space. Should I be taking approval from the state regulator before I do a securities offering? And there is some ambiguity in it. And that ambiguity has continued for the last 20 years since I started practice. But we all rely on opinion given by two committees of two well-known bar associations in New York, the New York State Bar Association and the New York City Bar Association. Those opinions are utilized in the course of our practice, and judges have deferred to them. So even if law doesn't exist, practice exists. When I became a transactional lawyer, I found the same thing when it came to legal opinions. We give legal opinions. There is no statute which says what an opinion must have or must not have. Yet the practice is so deeply embedded and lawyers and bar associations, ABA. Lisa has been the chair of the international section, a member of our highest governing body at the ABA, and continues to be. She can speak to these issues far more intimately than I can. But as a practitioner, I have benefited from the work which people like Lisa have done, which is to codify practices, to create standard forms, where essential, propose laws. And I think that's a lesson which I have learned by being part of these associations, that one does not have to wait for the legislature to draft something and bring it before us for effective rule of law. It is important that we as lawyers and our associations take upon ourselves, as people deeply concerned with the rule of law, as people who are intimately skilled in the practice of law, we have an important role to make sure that we help create the right laws. New York City Bar, I'm a member of the board of directors. It's an exciting opportunity to see how we influence day-to-day life and how we influence legislation. Choice of judges, choice of people who stand for elections at various state level offices. Take the case of helping people. The New York City Bar Fund, for instance, attended to 30,000 pro bono matters in the previous year. That is a mind-boggling number for a bar association of a city, but it speaks to the need that exists, and it speaks to our resolve to deal with it. And the City Bar Fund is the most well-funded part of the Bar Association. So much so that today we are doing repair and reconstruction of a floor of the bar building. And the City Bar Fund has actually lent it some money. So the City Bar Fund is so well funded by lawyers that they want, they understand, and they value the quality of life that New York City affords, only because there is rule of law and only because we care for the weakest. That's the message we give. Same thing when it comes to selection of judges, for instance. We review every judge's application for judgeship. We review his or her background, and we study it, we debate it, and then we bring out a report on what we think about it. The board deliberates it, the committee deliberates it. And I was lucky to participate in some of these deliberations and research and decision making. And I found, for instance, in the case of Amy Coney Barrett, and I may disagree with her altogether, yet when it comes to scholarship, incisive thinking, persuasive writing, she's second to none. And as lawyers, we evaluate different aspects, judicial temperament, how neutral and even-minded that judge is, and then we create opinions that get circulated. In the case of New York City Bar, among its 25,000 members, and to the public at large. The American Bar Association does things at a highest level on all of these aspects. As a member of its SciTech section, I got a chance to be part of a working group on the privacy law proposed by the Uniform Law Commission. It was an exciting opportunity to read those 150 pages and then comment on it and then take it up to the higher body. And then I noticed how it gets discussed by the council and then by the higher the governance body of ABA, and then the ABA speaks about those issues. These are not just helping make the right laws, they create the right temperament for lawyers to practice law. The other thing I noticed, which I benefit a lot from, but I benefited most when in my early years, was the ABA listserv, where you could ask questions to other lawyers and they would go to great lengths to help you. There is so many people I met in the process, and so much information and advice I obtained from them as to how I do a certain thing. How do I do this? I have a client who's asking me this question, and I don't have an answer. I will get answers from 10 people. I have done it in our own committee. And I remember you have given me advice on many matters. Shikhil has, Sanjay has. We use the ABA listserv for purposes of helping each other. We have a common goal. We are all wedded to the idea of rule of law. Literally wedded. Particularly, since I have grown up in India, studied law in India, came here, I know that our foundations are robust, that our belief in the primacy of the Constitution is constant. And I know that all of us endeavor to do things in accordance with the Constitution, and would love to see that when we raise this issue of climate change, for instance, which you have raised, and Sanjay has done a tremendous work with your guidance and inputs. And time has come when all of those work that is being done gets translated into making laws, and for us to help make those laws, and for us to contribute towards advancing this, like Lisa said, the crisis of our times. Rule of law and climate change, both of them are existential crises of our time. And both of them require enormous leadership and vision. And I think, like you said, the associations like ABA, SILF has done tremendous work, has been doing that for more than 20 years at least. And the economic associations like PhD Chamber of Commerce, FICCI, CII, I think the time has come for us. And I think that's the clarion call you want to give today, that these issues are not disparate issues. These issues are the existential crises of our times. And we as lawyers, we as associations, whether of business leaders or of lawyers, have to come together to deal with them. I would love to speak a little more if I have the time, but I'm mindful that you are keeping a close watch, and I respect that. And this has always been your quality, and I'm actually reached the end of my time, so I must stop here. And thank you very much. And also want to thank Atul Kapoor, who's my senior, and also who grew up in Lucknow like me, and who gave me some very valuable insights on what we'll be discussing today. So thank you, Atul, for that.
Thank you, Jaipat. We would also have loved to hear you more but I also believe that brevity is an art, and whatever you had to say, you have said it in a very, very assertive manner, briefly, but touched upon all the important aspects, particularly the matter about the practice of law. The practice of law is the most important thing. Let's forget about the laws, but let us try to practice what should be there in the laws, what the laws' spirits are, how to implement properly, you see, the laws. And if there are no laws, still there could be practice which can eventually be codified, as you rightly suggested, that you have suggested to the American Bar Association, that even if a law does not exist, you see, there could be a code of conduct or code of how, you see, one should achieve the goals of the profession. I think it's a very, very timely message that you have given. But need not wait for the legislatures to make the laws. You can yourself suggest, even formulate the laws, even send it to the legislature for their consideration. If they accept it, well and good. If they don't accept, at least we could start implementing the spirit of that law which we are suggesting to the legislature. So how in the US you could influence, you see, the lawmaking or even selection of judges. I think these are very timely messages for India also, if we could have some of these. And for that now we have to turn to our Indian specialist speaker, Mr. Amit Kapoor. Amit Kapoor is known, you see, to all of us. He's not just known, you see, within India, but his clientele and his name and fame is across the globe. He's the joint managing partner, as all of you know, of JSA since, and he has been a partner since the year 2000. He's regularly consulted on infrastructure, regulatory and PPP issues by several ministries, bodies of central and state governments, developmental financial institutions like the World Bank, WSP, ADB, competition and sector regulators, and leading Indian and foreign corporates like the Tata Group, Adani Group, GVK, and so many others. It will take me full 15 minutes to read out, you see, and then we won't be able to have his presentation. So I think I must stop here, and it is indeed a pleasure and privilege to have a person of such eminence as Mr. Amit Kapoor to deliver, to share his views on this very important topic, which has been dealt with from the US perspective by Mr. Jaipur Jain. Over to you, Amit.
Thank you, sir. Dr. Bhasin, Ms. Audrey Slover, Judge Taylor, and all my colleagues who've spoken before me, as also colleagues who've joined in. Good morning, good evening, depending on where you are. It's been most interesting to hear views across the board. And may I start by reminding ourselves of the famous theory that Roscoe Pound brought about law being nothing but social engineering. And that is the heart of the matter, so far as I'm concerned, if you look at economic cooperation. The movement of goods, the movement of capital, and the movement of people is not of as recent an origin as we would like to believe. When we talk about law merchant, though we will not ever forget the salutary contribution of Lord Mansfield, because it was right up to the 1st century AD, recorded history shows that there have been trade transactions across. Kautilya's Arthashastra records it, Roman literature records it, and all of these came at the back of certain rules that we followed in our contractual arrangements. Because at the heart of any transaction of that nature, whether it's people, goods, or capital transferring from one country to another, goes at the back of some fundamental requirements of predictability and enforceability because otherwise why would one move and put oneself to peril? And that, I think, is at the heart, and I completely agree with what has been stated earlier. Jaipur, thanks for that call that we spoke about, and that's all thanks to this forum. We connected after some 12, 13 years where we had spoken sometime earlier. And for the first time, Dr. Wasim discovered that we both had studied in Lucknow and had some very interesting anecdotes. So while we started with a discussion on economic cooperation, we did many other things other than that, but that's another story. So all I would commend for all of us to consider is, and I completely agree with Lisa's point, I think we need to go beyond what John Kerry said, actually. I have been an advocate of climate consciousness, which is cross-cutting far beyond lawyers. It has to go into the heart and thinking of governments, of citizens, and civil society. It should be as cross-cutting as finances. It is foundational. It's fundamental for us. So when you talk about people, you talk about goods and services, you talk about capital, and then you talk about technology or environmental externalities, there are no national boundaries. Whether we like it or not, that's how it is. And yet, from the Second World War, the Bretton Woods institutions are under pressure over the last 4 or 5 years, maybe a decade now. We are seeing reformation of those. There was no need for a Quad. There was no need for the Indo-Pacific if the world had worked on the UN forum, resolving issues and moving forward. But the need arose, which tells us about the dynamic realities in changing times. And I think that's where our profession has the genius of coming forward and offering solutions well before the legislators come up with laws. US has led the story in terms of recognizing advocacy and lobbying as a legitimate exercise. India does it, but it does it more from a B2B, B2G forum, where you interact through the forums that we talk about, whether it's a CI or a FICCI or it's an Indo-US corridor or Indo-UK fora. There are committees appointed by the government where people from civil society, from private and public sector and professionals are staffed together. And I think that's where the genius of the profession is. Given our experience in dealing with, on the commercial side, I'm a litigator, but I have also done many transactions and restructuring and reforms. You would always, as a professional, understand risk and value. You put yourself into the shoes of your clients, try and appreciate and understand what they are facing, find an answer. And I think that's where the innovation, the contribution of our profession lies. You don't need to wait for the parliament to enact laws. There are constitutional values and fundamental principles of rule of law that the common law gives us. And those guiding principles should be able to facilitate us in engaging with our clients in what the economists would call a mechanism design, or we as lawyers would follow as the mischief rule to draft new frameworks. And that's the whole thing. It's about exploring possibilities. It's about evolving mechanisms and frameworks. And it's about eliminating risks and barriers. And I think lawyers are quite capable of doing it. They have done it all the time. And that's where I refer to Lord Mansfield's salutary contribution. Law merchant, as we know today, was substantially and significantly his contribution. England was, of course, at the forefront of the Industrial Revolution and as a trading hub. And he realized when he became the Lord Chief Justice that perhaps the law had not kept speed with the needs of trade and commerce. And so, Jaipur, pretty much what you said about the lawyers calling the ships and the banks, well, there you are. It happened then, it happens now. And I hope that we are able to be wise enough in these fora, whether it's ABA or IBA or it's this fora and the various other platforms that we have, that we are able to foresee it and not wait for crisis to emerge, but are able to find solutions and offer alternatives. And the challenges are upon us: cryptocurrency, terrorism, cooperation while saving yourselves from cartels, technology and IPR issues, safeguarding the IPR while simultaneously making sure that the vaccine is available, that people don't die waiting for it. The challenge of green capital, ESG, SDGs and their implementation. These are all challenges that our times and our generation has faced far more. And we could do no better than to see the accelerated pace at which technology has moved. GDPR and privacy was not something we would have thought about. 20 years back, mobility was not a worry. You left your home, and then wherever you reached, you could pick up a payphone or land up at some place and tell people. And people wait for a few hours before they started panicking. Today, if you don't respond in 2 rings, the 3rd ring is a panic station. What happened? Where are you? So that change in technology, what Entorser versus Miles recognized in UK, and what Govardhan Das Kedia in that salutary judgment of Justice Hidayatullah recognized in India, is a clear example of how law meets and comes forward to offer answers. And there is the basic test of what are we going to do as we move forward. The world is changing. At the beginning, Judge Taylor referred to a few events that have happened, as did Dr. Bhasin and Rohit. And those events have changed several things around us, whether it is the war which is going on in Ukraine, climate change, issues that have been talked about by other colleagues in terms of terrorism and otherwise. There is a need for cooperation on various fronts. And yet we find that the multilateral institutions that came at the end of World War with the Bretton Woods is completely falling apart. That's the opportunity. And that's the clarion call for the profession. We need to step up to the plate, try and cooperate amongst ourselves to find those tracks for pathways for growth. Because ultimately, citizen and common man is not looking for political agenda. They're looking for employment. They're looking for opportunity to grow, to actualize a technocrat's dream or ambition of finding a new solution for a problem that has bugged people around, innovating, and therefore creating value. And there I believe that our profession has much to offer. I have personally benefited, just as you said, Jaipur, many a times in acting for several years now. Over nearly 2 decades, I have sat in various committees at CII and FICCI, worked with the government, worked with the businesses. And there have been enough opportunities, without citing cases, for instance, where one has been able to influence clients who are corporates and would normally, in our perception, be chasing only profit, to withdraw a particular claim, to concede a claim, and to find solutions. And that is the genius. The profession does offer us that opportunity, because in our profession, when we work alongside people, we find those problems. We understand those problems, and we are able to offer at times solutions which could find a path forward rather than a roadblock. And there, I think, is the issue that we need to see. I have benefited by participating in various committees where legislation was taken through the parliament. The last one was with the Kelkar committee with the infrastructure development and enforcement of contracts. I was fortunate to be the one who started the litigation in India, where I think we are the only Supreme Court in the world where in common law jurisprudence, change in law in a nationalized commodity is not a defense for failure of contract or non-performance. It's actually a ground for restitution. It's only a district court in the United States that has a judgment of that nature in Alcao case. And so there are pathways in which we have found solutions and we have broken up. And that case in spite of the complexity of public finance policy and affordability in our political commodity regularity, still traveled from the regulator up to Supreme Court and found answer in 4 years and 8 months. And it's been implemented. So while we know and we like to often refer to our challenges of baggage and delays, here is an instance where I can offer, and there are several others I could offer, where we have found answers within months and years. And therefore, I think it's a great opportunity to meet and connect with all of you. I would love to see how this forum can take it forward in finding some of those pathways rather than leaving it at a dialogue where we exchange our 15 minutes to each other. And I think that will be the challenge. Can we actually pick up the threads out of today and find in those 4 topics, which are so critical for today and tomorrow, that Dr. Bhasin has curated for us, where we could combine and come back with some white papers to push on both sides. After all, Indo-US bilateral is today at the strongest track that it was ever. And here is the opportunity. So without having been called upon it, may I use the opportunity to request all of you to join me in trying to see if we could converge in these areas and try and build something out. I will keep ahead of time, sir, and leave some more for my colleague, and maybe there will be some dialogue.
Thank you. Thank you, Amit. I think that was brilliant. This was just as as is, if you watch the television and channels, this was the first season. There will be a second season, possibly followed by third season, and your suggestion is taken very seriously to have a sequel, to this discussion, because it is an unending topic and a very important topic. All these topics combined into one. The role of legal profession in the face of the perils that we are facing, both in terms of challenge to rule of law in different jurisdictions, and also with regard to the perils of climate change, and in some areas, the diminishing role of the legal profession, unlike what is there in the United States and in India, where we have some sense of responsibility. So you have very rightly highlighted the oft quoted thing that law is nothing but social engineering, and that there is a need to have the climate consciousness. And you echoed what Jaipur said, that innovation by lawyers need not wait for laws. Innovation can come on its own, and it has to come on its own. Possibly then it can lead to some law. But first and foremost, the innovation has to be there. And then exploring possibilities, that is the role of lawyers, able to foresee the problems and to provide solutions. I think that is very important, but very, very relevant. And your final clarion call, as you called it, try to cooperate and find pathways. I think that will be borne in mind when we meet again to find the pathways. So many thanks. And now I have great pleasure in welcoming and introducing to all of you Mr. Ronak Desai, whom I had the privilege of meeting when we visited Washington. He leads the congressional investigation practice at Paul Hastings LLP, as well as the firm's India initiatives. He served as a trusted advisor to the US Congress, particularly on issues relating to India and the subcontinent. He served as a counsel to the United States House of Representatives and vice chair of India practice at a prominent law firm. Last year, the American Bar Association recognized Ronak as one of its top 40 under 40 attorneys. So I think it is a fitting finale to this, that we have such a young speaker, the next generation of lawyers, to share his views with us. So over to you, Mr. Ronak Desai, on the topic of mutuality and commonality of laws of the US and India. So please, over to you.
Absolutely. Thank you so much, Dr. Bhasin, and to really everyone here for the opportunity. I know many of you, and we've spent so many occasions together, both in the US, also in India as well. And unfortunately, with the pandemic, in-person events have become far and few between, but seeing so many familiar names and faces, and even getting the opportunity to reconvene virtually is incredibly welcome. And, Judge Taylor, Shikhil, again, so many just friends, old and new, and I'm glad that, we're gonna get this time together. I've got, a tough task ahead of me with so many distinguished speakers that have come so far, that have covered such a wide and diverse range of topics on so many important themes. And one thing that struck out at me is, I spend a few minutes just discussing with you, and perhaps with Dr. Bhasin's permission, I can address a topic slightly adjacent to this idea of mutuality and commonality between the laws of the two countries, is this theme that things are tough right now, right? I mean, division, challenges in both countries, I think, especially in the United States, as Judge Taylor rightfully pointed out, has increasingly become ubiquitous in the norm. The number of developments, especially in US law, the changes in the Supreme Court, the way that's impacted the jurisprudence of the country here, I think have further exacerbated divisions, further exacerbated challenges, compounded so many of the problems that afflict the country. And as we were talking earlier, I mean, climate change or whatever it may be, again, this idea that there's so much hard work ahead of us, and finding a pathway forward and understanding the absolutely indispensable role that attorneys play, and especially organizations like the ones that have all come together today, I think just have come into sharper focus as we move forward. But given that I'm the final speaker, so to speak, if we do have time for some Q&A, I thought it might be prudent and perhaps even welcomed if I focused on some positive developments here, especially on the US-India side. And one thing that I've always been fascinated by in my own practice, something that I've noticed my own clients constantly talk to me about and ask me about, is how laws that we pass here in the United States, statutes that we enact here, impact other countries around the world, right? And one example that came into sharp focus for me just over the last few months, and I think very topical given all the themes that so many of you have so expertly discussed over the last hour and a half or so, is one of CATSA, actually, right? The Countering America's Adversaries Through Sanctions Act. And again, as I was doing a survey really of American law on reproductive rights, or American law on anti-corruption, American law on data privacy, American law on intellectual property, and then comparing those to its Indian counterparts, what I was really looking for were some positive developments that we could focus on to say, look, here's an example or a case study where you have a law that I'll spend a minute talking about, impacting not just India, but many countries around the world. Something that so many naysayers and critics thought were going to be a challenge, a hindrance to bilateral ties between the world's oldest and largest democracies, but ultimately, as we just saw over the last week or so, has turned out to be a real success story. And one thing I want to highlight as part of that story, and again, my congressional background is going to betray me here, is that at a time where our government in the United States is utterly paralyzed, there's agreement on virtually nothing, political paralysis and excessive partisanship is the norm. It's become the governing standard here in the US. The one thing that the United States Congress and the US government and these two parties can agree on is the importance of the US-India relationship. And let me spend just maybe 2 or 3 minutes talking about the background of CATSA and what's happened, and then going into, I think, what the implications are and where things stand. And part of that story is the role that attorneys have played, Indian-American attorneys have played, in really serving as custodians of this absolutely crucial relationship. And the instance where we have, members that were actually born in India who have pursued very illustrious careers in the law, coming to the US Congress and ensuring that they play this indispensable role in keeping the two countries close and keeping this partnership robust. So if we look back to CATSA, and Judge Taylor and a few other speakers touched upon this, the Countering America's Adversaries Through Sanctions Act, which was enacted by Congress in August of 2017, was really the product of the turbulence surrounding Donald Trump's election and his purported ties to some foreign countries. And what's interesting about that law is it passed with remarkable bipartisan support. And the law basically said, look, any country that does business or conducts business with North Korea or Russia or Iran could be exposed to sanctions. And there's a whole section 231 of that act that focuses on Russia and the idea of significant transactions. Any country that conducts a significant transaction with Russia and any of these instrumentalities or entities of the Russian government, which of course includes defense companies, could very well face exposure through so-called secondary sanctions. And as the legislation was making its way through the United States Congress, it became very clear that this was going to impact a number of countries around the globe. The EU actually expressed strong reservations about the law, one of the US's closest partners, countries throughout the Asia Pacific, and of course, India as well. And what I've come to learn just based, on my own perch, and if we take a panoramic view, is that we always find many critics and naysayers who always are willing to herald turbulence or the demise of the strategic partnership between the US and India, but the reality turns out to be different. The law gets passed, of course, in August, and India makes very clear that part of its needs, its defense needs, are going to encompass purchasing the so-called S-400 Triumph missile system from Russia. In the US, I think the discourse and debate was quite robust. It was quite heated about this idea that India needs to pick sides. India needs to not conduct business with Russia. And again, it shows, in my view, an ignorance of India's own history, of India's own needs. But fortunately, I think for this country's legal and foreign policy establishments, there were enough voices that said, wait a minute, let's take a more nuanced view. Let's see what actually happens. And, something that we talk about often is the so-called bipartisan consensus surrounding US-India ties, of which, of course, lawyers are a big part. It's this idea, it doesn't matter which party is in power in the United States or in India. It doesn't matter which leader occupies the White House or the Prime Minister's residence in New Delhi, that ties overall are going to be strong and robust, that the underlying strategic logic is going to drive this forward. And so many critics thought CAATSA was going to be a problem. And yet, lo and behold, less than a week ago, about 8 days ago, I should say now, the United States Congress and the House of Representatives, where I spent some of my professional time, under the leadership of Congressman Ro Khanna and Brad Sherman, who are the vice chair and chairs of the India caucus, respectively, they were not only able to get a so-called amendment to the National Defense Authorization Act. This is the big multi-billion-dollar defense bill that Congress passes every year. They got an amendment passed that basically said, our relationship with India is simply too important for us to allow the threat of sanctions under CAATSA to be hanging over the relationship's head. This relationship and this country specifically requires a waiver. And the remarkable thing is, not only did they get passage of the amendment, it was passed with an overwhelming bipartisan majority. Nearly, I think, 400, almost 300 votes, a couple of abstentions, but that's something that you never see in the United States Congress. It's what we call a unicorn, so to speak, where you can find such margins. And Dr. Bhasin mentioned, the very, I think, fruitful visit he had to Washington when we last, I think, saw each other, at least in person, where we were able to meet, for example, Congressman Raja Krishnamurthy, someone who was born in India and came to the United States and ended up having, again, this very illustrious career in the law. The fact that we now have Indian-American members of Congress in the House, there's 4 before the vice president became the vice president, we had 1 in the Senate, shows you just how crucial it is. No surprise, they're all attorneys, no surprise they've been very active in organizations exactly like this one, but shows you just how crucial it is that, we're able to see how individuals like that with the support of groups like this can really serve as at the vanguard of the bilateral relationship. And we're seeing concrete impact of saying, look, we recognize that our laws have an impact around the world, but we're going to take steps to ensure that our friends and partners are insulated against the adverse consequences of those laws. And what's going to be interesting, again, is as we see these leaders in the Congress, especially, and also in the White House. And I should note that ultimately it's the White House that has ultimate authority over a waiver for India on CAATSA. But that policy and the decisions that are driven at the White House now have such unprecedentedly strong support from Congress. It'll be interesting to see how these leaders continue to navigate the relationship and the role that they'll continue to play to ensure that it reaches even further heights. And look, in an otherwise dismal landscape, as I'll call it, where the challenges seem to far outnumber the wins and the successes, listening to, again, just the eminent panel here under Dr. Bhasin's leadership, it really just made me think that, we can, as a group and as a profession and as an industry, secure some victories and really safeguard, important causes and important relationships for the foreseeable future. And again, I know I'm a little bit ahead of time, but let me pause here just because I know there might be questions, and I want to give folks again on the virtual panel the opportunity with any closing remarks. But let me again just express my profound gratitude to each of you, and to end at least my remarks with a hint of optimism. That I think with all of us continuing to be engaged, with all of us continuing to have the friends that we have both in Parliament and in India, or excuse me, the U.S. Congress, that there is no real limit to what we can achieve together if we're willing to work cross-border and hand in hand to achieve some of those aims. So again, thank you all so much, and looking forward to any questions and any remarks that you all might have.
Thank you, Ronak. I think that was really a fitting finale to this summit. Hearing these words of wisdom from you, it is all right, for the governments to cooperate with each other, the US government and the Indian government. But what is more important and significant, which you very rightly pointed out, was the understanding and cooperation between the people of the two countries, you see. And people are represented in the legislature. Therefore, for the first time, we have seen, as you rightly pointed out, such massive support for the waiver given to India, that CASTA against the Russian sanctions and all that. I think that was a very significant development in the recent times, which was earlier not available. Earlier, the administration was sympathetic, but possibly Congress was not sympathetic. But this was one occasion, so far Indo-US relations are concerned, that there was a convergence, and a massive convergence, you see, of the views. And I think India stood benefited. And in the process, the Indo-US cooperation also stands benefited. So Absolutely. This is just the beginning. And I hope this will be carried on with the people like our worthy speakers today, our Solicitor General, who represents the face of the government of India in the courts, and also by Audrey Slover, who represents the US government in the US embassy, and representing, you see, the judiciary, we have Justice Honorable Judge Sanjay Taylor, the presiding judge. And then we had the benefit of Mr. Shikhil Suri and the bar leader, Lisa Sevit, who was the chair of the section of international law, and then Mr. Sanjay Notani, and a dear friend and a bar leader in his own right, both in India and in US, Jaipur Jain, and then Mr. Amit Kapoor, one of the most distinguished lawyers in the country on the law firm side, being the joint managing partner. And finally, your address, Mr. Ronak Desai, I think it has hit the nail on the head, and I think we'll take it forward with that. So I take this opportunity of thanking all of you. It was really a pleasure for me personally, and I think for our Society of Indian Law Firms. And I can assure you that I have a list of about 60 top law firms who have participated in today's proceedings, all the big ones, and of course there are others also. So I thank you very much and wish you a good day wherever you are, or a good night wherever you are. So thanks a lot. So thanks particularly to Justice Sanjay Taylor and Ronak and Jaipur Jain and Lisa, who have participated from the United States. Thank you very much. Thank you.
Thank you all so much.
Thank you.
Thank you. Take care.
Lalit, this is Sanjay. I'm going to follow up with you regarding a judicial exchange trip to India in early 2023, okay?
Look forward to that.
Okay, bye.
Yeah, great, bye.